Here, I want to thank Judy for the invitation and for her patience in working through all the logistics it takes to get us here on a Saturday. I do have to say, it's been a very busy week for the court. I will undoubtedly step over my own words several times. The PowerPoint doesn't necessarily tie up with the way I'm doing the presentation, so I'm going to try to make that all work. And I do want to thank you for inviting me to be here on a Saturday afternoon. Because you know this is just what I wanted to do. But I really seriously am grateful for the opportunity to be here because I think we need to have an important conversation. I'm going to get a little bit serious in the beginning. First, I'm going to see if I can make this work. Nope. Clearly, you know, that noise. There we go. How did that work? Okay. So I'm going to talk to you about 3 different things today, and because of the timing, I would invite you to stop me and ask questions at any point that is on the topic I'm on. We're not going to have a whole lot of time at the end, I think, for questions, and I don't want to miss any of your questions. So the first thing I'm going to talk about today is what I think is critically important to the judicial branch and critically important to the press. And that is that we have a shared goal. And we need to work to make sure that we're all aiming at that shared goal. We'll get to that in a minute. Then I'm going to talk to you about innovations and changes that are going on in the judicial branch right now, so you'll understand the context in which things are happening, and you will know why everything is going to seem a little bit chaotic for a while. Probably seems chaotic all the time, but it may be more chaotic in the next year. And finally, I'm going to talk to you about the planning for access to digital court records. And there's a whole process in place. You've been very much involved with us before now. I will encourage you to be involved going forward, and I'll show you how you can do that. So, part 1, shared goals. So this is, as Judy told me, a keynote address. I always worry whether keynote means something particularly special, and at the end you can tell me whether it's been special. But because this is a keynote address, I want to start with a key belief. And I want you all to know that the members of the 3rd branch of government and you, the members of the 4th estate, do in fact have a shared goal. And that goal is that the public should have access to timely, accurate, and helpful information about what is happening in Maine's courts. So this goal, which should be our guiding factor as we all work together, is something we cannot ever forget. The public needs access to accurate information. They need it when it's meaningful for them to have, so that's all the timely piece. And they need it in a way that is helpful to them. They need to understand what they're seeing. So it is, I think, important for all of us to remember Walter Cronkite. You're all too young to remember who he is. Walter Cronkite said, "Journalism is what we need to make democracy work." And then Bob Woodward said, "The central dilemma in journalism is that you don't know what you don't know." I want to make sure that you are never in a position of not knowing what you need to know about the court system. So we'll talk about how we're going to try to meet that goal, but then I have to do this. You just have to forgive me. So, Walter Cronkite was one of my heroes, but a publicly trusted, neutral, responsive system of justice is really what we need to make democracy work. And you can quote me on that. So I'm going to be up on one of those quote lines. We all really have the same goal. So let's talk about what's necessary to make that goal be a reality in the state of Maine. And I'm going to stop here and do a little plug for the state of Maine. every once in a while, I can scrape together enough money to get to the Conference of Chief Justices, where I meet with 52 other state court chiefs, 2 because we have Guam and the Virgin Islands. And they're lovely people, and we all talk to each other about the problems and challenges we're facing. And I come home from every one of those meetings just absolutely thrilled that I grew up and I work in Maine, because we all talk to each other, and most of the time, our modus operandi in Maine is problem solving. If we have an issue, we get together to try to solve it. And I'm really grateful to work in that kind of environment, and I think it is incredibly important for us to communicate. So you will find on the back table here, there are some fact sheets. You can take them, copy them liberally, give them to the new people that you work with, keep them in your cars. They have the contact information for the important people in the court system who can get you the information you need. Because the court system is not like other areas of government. Many of you know this. I look out into this crowd and I can see people who know full well you will hit roadblocks when you're looking for information in the court system because of the different roles that we all play in the system of justice. When you hit a roadblock, don't just assume you can't get public information. You need to get to the people who can get you what you need. So today, well, let's see if I did this right. I did. Okay, well, there you go. The Administrative Office of the Courts is run by Ted Glessner, who's now going to stand up and turn and wave. This is the head of the AOC. There you go. See, wasn't that fun? It's a good picture. I think that's a golf course behind him. I don't want to talk about that. So Ted knows everything about the court system. And what you will find is that Ted goes back to the Wathen administration. Dan Wathen stole him fair and square from another state, and Ted knows everything about how the system runs. He knows where all the judges are. He knows how to get information, and he knows how important it is to me that you get what you need if it's public information. So he is the backstop for everything here. But beside Ted is Elaine Clark, and here's what we're going to do. So Elaine is going to stand and wave to you and tell you that notwithstanding an order of the Chief Justice, she declined to send me a photograph that I could put into this PowerPoint. So you're going to have to commit her face to memory. So Elaine, let me just make sure you know, Elaine is our director of both internal and external communication. And she is, so some of you have worked in and around the court system long enough to know Mary Ann Lynch. She is Mary Ann Lynch. And she is filling the role that Mary Ann filled, and she's taken on some additional responsibilities. So when you need quick access to a docket, to a file, to a document that's a public document, when you want to know if the judge can or cannot talk about something, Elaine is the person. She's left a pile of her cards back there. I would encourage you to take those cards with you. She promises me that she is available 23 hours a day. So, and if you're trying to reach her after hours, the phones send your message through email to Elaine. So if you've got a timing problem and it's outside of the court's hours, Elaine is the person to talk to, and Elaine can find the chiefs. So the chiefs, actually, many of you may know, these are the trial court chiefs. So Roland Cole has been on the court for what, 527 years. He is the Chief Justice of... So I thought we were off the record today, and I see a camera in the back of the room. If Roland sues me, I'll be in touch with him. Roland is the Chief Justice of the Superior Court. He's assisted by Bob Mullen. Some of you will recognize Justice Mullen. He is the one who just went through a relatively public process of encouraging people to appear for jury duty and helping them understand what it is and what it is not, and how we can work around people's lives to encourage a broader spectrum of the public for jury duty. Chief Judge Susan Oram, she's the chief of the district court. The district court is the busiest place on the face of the earth, and right now it's about to become even busier. And Susan Sparaco is her deputy. The chiefs can find things that nobody else can find, and sometimes when you need a judge to give you some background about how the system works, and you know you cannot talk to the judge on the case itself, sometimes the chiefs can talk to you on background. So that's just something to keep in mind as we go through this. So, oh, and I'm just going to give you this. Does it work? This is the Supreme Judicial Court of the great state of Maine. I always have to find a way to put that photo in because I was having a really good hair day. So, and that's rare these days. So it's a good looking bench, and there we are, just in case you were wondering. Okay, next things. Let's see if I can, maybe I should just leave that up for you so you can. All right, so before I get to some more information about what's actually going on in the court system right now, the judges had a judicial college right here, this very room, that room. We had dinners and lunches and kvetched about everything in the world. And I said to them, I'm going to speak to the Press Association on Saturday. What would you like them to know? And what I didn't do, and I should have done, is make it clear that for the most part, all of the judges are grateful for your efforts, which have been really clear in recent years, to get it right, to get the story right, to understand what was happening in a case, to make sure you know what the process is, and to talk with us to get what you need. So it was almost entirely positive. These are the few little things they would like you to help with. One of them, accuracy in reporting, and a number of them went out of their way to say the reporting in Maine these days is very accurate. And for the most part, what you're reporting helps the public understand what's happening. One of their biggest complaints, though, is that the headlines do not track with what's in the articles. And the headlines are not apparently written by the person who has painstakingly checked the facts for the article. And because of that, the headlines are often inaccurate, at least this is what my colleagues are concerned about, and they are often the only thing that the public reads. So I know that's painful for you to hear, it's painful for me to hear, but if you get up to a headline that says, "Judge beats litigant in open court," and the article says, "and on a quiet sunny afternoon, the judge heard the case and did a good job," nobody reads the article. What they read is that headline. So their request is that you find a way in your systems to fact-check headlines as well as you are fact-checking the articles themselves. The other issue that occasionally pops up, and usually only pops up when you and your folks are in transition, is that someone will not understand where they are in a process. So there's a misunderstanding of the judicial process, and that means that the words do not track with what actually happened in the courtroom, because it's actually only a bail review, it's not a trial, or it's a preliminary ruling, or whatever is actually happening procedurally was not understood by the reporter. And so we would just encourage you, if you have any questions, to call Elaine. She will get you the information, she'll get you the statutory citations so you can see what's supposed to be happening. And the other thing that you've all been much better about in the last many years is making sure that everyone in your profession understands that a judge's role in an individual case prevents a judge from speaking about what's happening in that case. And when I was a baby judge, we had a lot of instances where, boy, that was a long time ago. I'm getting old. We had a lot of instances where the article would start with, the judge refused to return the reporter's calls, or the judge declined to speak, in a way that sounded like we're trying to hide something. Judges can be sanctioned. One judge was actually taken off the bench for talking about a case in mid-work. So if something's going on in a court and you want to talk to the judge, you will first find us running down the hall because we're just trying to save our jobs. And then you will find that we don't return your calls. What we will do, and what we've gotten better at, I hope, is saying to Elaine, the press is looking for information. Please be in touch with them, make sure they get what they need. I can't talk to them. So if you can just make sure, and you've apparently been doing a very good job of that, if you can continue that effort, that would be very helpful. This one, whoop, we're way too far ahead. There we go. This one, acquittals. So this is a pet peeve of judges, and 'twas ever thus. And I've talked to Chief Justices in other states, we've talked to PIOs in other states. You are apparently afraid of an editing misprint that says the jury found the defendant not guilty. Instead of saying not guilty, the not gets dropped, and you will have a defamatory sentence, the jury found the defendant guilty. So instead of using not guilty, many of you are saying the jury found the defendant innocent. And that is not what a jury does. And it's not just a matter of semantics. It's very important in the way the court system works for people to understand that the juries in a criminal matter do not make a finding of innocence. In a civil case, they may well find that the event did not occur. But in a criminal case, the jury's only job is to determine whether the state met its burden beyond a reasonable doubt. And if they find the state didn't meet that high burden, they acquit. But it confuses people if they think a jury has determined that someone was innocent and other matters, including civil cases, continue to go on. So if you could work on those concepts in that language, we would be ever so grateful. And again, for any factual information that you're going to report about the court system, if you want confirmation, have I got the names right? Have I got the name of the kind of case right? Have I got the judge's name spelled correctly? Any of those kinds of things. Elaine can give you quick information, she can give you more information, anything that's public, she can get for you. So, while we're at it, this comes as no surprise to anyone in this room that there are actually 3 branches of government, that the Constitution says that we work separately, we do not do each other's jobs. We live in a world in which many people don't understand that simple trilogy. And it is alarming to me how often people will ask me questions about why didn't the court control that actor when that actor is part of the executive branch. And that happens on a not infrequent basis. I just spoke to a large group a couple of weeks ago, and some very smart, very thoughtful people asking good questions about how the courts work believed that the district attorneys, the prosecutors, were part of the judicial branch. So to the extent you do your own internal education, these things are actually fairly important. We can give you more information about what the state court system looks like, and that's just a quick overview of what logistically the state courts are made up of. You will hear me saying all the time, our courts do not have programs. We have people and we have buildings. And these days we have technology, but that's another story we'll talk about. So we have judges, we have clerks, we have security, we have administrators who keep the bills paid. That's what the court's made up of. There are 36 courthouses throughout the state. We used to have 46, that's wrong. Fact check that, it's 42. But we have reduced the number of courts by 6 simply by consolidating courts that used to be across the street from each other. So the public doesn't get embarrassed and confused when they're in the wrong place. And so we only need 1 set of entry screeners, so there is money to be saved. So that's just a little bit. And here's the court structure, and this is intended to help answer one question I get regularly. So you will see the district and superior court each have their own jurisdictional areas, and they share jurisdiction of all criminal cases. And any of the appeals come to the Supreme Judicial Court sitting as the law court, which is different than the Supreme Judicial Court sitting in original actions, and that's a long story and you don't care. The probate courts, the elected judges in the probate courts, do not fall within the state court oversight. Cases from the probate courts can be appealed to the law court, to the state Supreme Court. But the probate courts themselves are individual, independent, elected judges who are their own authority within their own county and not subject to the oversight of the Maine Supreme Judicial Court. Okay. And the next one is just so you know what not to blame me for. So there are federal courts. I won't go on at length about how many fewer cases the federal judges have and how much more money the federal judges make, or the fact that the federal judges keep stealing our best and our brightest. I'm not bitter at all, and so we'll move on. But those are the federal courts. They do not fall within any sort of state jurisdiction. The probate courts we've talked about. The good news in Maine is that the tribal courts, which again are not within the jurisdiction of the state court system, the tribal courts are actually in Maine working really well with us. We have a collaborative relationship with both the Penobscot Tribal Court and the Passamaquoddy Tribal Court. We do some cross-systems work for probation, for addiction recovery, for all of the kind of community-based services. And I've been very grateful that tribal leaders in Maine have stepped right up and come to the table with state court leaders to make sure when we are adjudicating around their communities, we're all working together. So that's actually a little piece of very good news. So, any questions as we move to innovations in progress? Does that all make sense? Do you know? You already know all of that anyhow. Okay, great. So this is the part of the presentation where I say to you, have mercy on us. We are about to launch into a period of time when many changes are happening at once. And we will stumble, we will get back up, we will try to be open and honest about what's going on. We would encourage you to ask questions if things aren't working. I know, I get no sympathy, but we're all working really hard. So let me start with what is keeping me up at night. We are launching in Maine a complete cross-court digital access for every kind of court record. By 2020, we would, thank you, yes, well, yes, but light candles, you know, I've watched every state that has started this, and what we find, and Maine is very lucky we have a unified state court system. In states like California, or Texas, or even Colorado, all the court systems are sort of these huge groups within the state. We are able to bring everything under one umbrella, and all of the judges are working on this at once, and so all of that is really good. It's scary. It is enormously complex in a way that I hadn't appreciated when we started work. Every time I get called on to make particular policy issues one way or another, the questions never stop coming, and it is startlingly difficult to put the system together. So the first one that we're doing is the Violations Bureau, and So what you have right there, you see that date at the bottom? That's why I'm looking very tired. So is Ted and Elaine have not slept in months. On October 29th, that is a week from Monday, the brand new Violation Bureau digital system will launch. We already have several police departments that are doing digital ticketing. So the information will immediately populate our system. If you get stopped for speeding, you will get a paper ticket to take home with you to remember the wonderful experience. But the information will get to the court system immediately, so when you go to figure out what's going to happen next, you don't have to wait for the officer to have delivered paper tickets days, weeks, occasionally even longer than that, to the court system. You'll be able to go right online and to say to the court system, it's a guide and file. You may have heard of this kind of system that's being used across the country. Do you want to challenge your ticket? Do you want to pay your ticket? And you can do any of those things, set it up, then you'll get a date for your trial if you want a trial. It'll tell you how to pay if you want to pay, which we will always take that money if you would like to send it to us. There will be a few glitches as we start, and a couple of those are, the search engine's not ready yet, right? So there will be a search engine. It's almost ready. It will not roll out next week, but in a couple of months, you'll be able to go online and put Ted Glessner's name, don't put mine, put Ted Glessner's name into the system and ask how many traffic tickets he's had. And the system will tell you the last 10 traffic tickets Ted has never had. And you can look yourself up, you can check people who are in various, so you will be able to find the last 10 tickets that any person who's driving in the state of Maine has had. Yes, sir?
Will it also be able to tell us those people whose licenses have been suspended?
The suspension of a license happens at the Secretary of State's side. So soon there will be a good bridge, but for the most part we'll be referring you to the Secretary of State on the suspension issue. And there are lots of things happening with suspensions, including a reduction in the number of times that people's licenses will be suspended for failing to pay non-traffic related fines. So there are a whole bunch of new things happening in that arena.
But will it go back historically?
It'll go back the last 10 tickets. So if the last, yes, have we?
So I have 10 tickets since 1978, and I go search my name. Will they all be in there in 2018?
It will go back through our preceding computer system and anything we were able to get into the old system. But there will be some legacy data that has not come in.
Okay.
So, so what I say to everybody is, you can get good information, but do not assume that it is entirely complete. We just don't have the technological ability on that one yet. And the legacy data it was cleaned very well from our last system and has moved into this system. So we think that's all going to work really well. Okay, so let's see what else. We are working on civil process reform. This is just a huge undertaking. You will probably not see things changing very fast, but what's happened is across the country, you may have read the stories on the disappearance of the civil juries, or the disappearance of civil litigation in the courts. People have gone to private litigation. We know that civil cases take too long and cost too much. I know because when I speak to groups like Lions or Rotary or those kinds of groups, people will say to me, I'm a general contractor. My sub walked out and left me holding a $20,000 bill. So I'm out $20,000 on a job that I would have earned $23,000 on. And this is terrible for my business, and so I went to my lawyer, and my lawyer says, I will try to collect this for you, but it's going to cost you $25,000 to collect your 20, and I'll take half. So the system isn't working. And we are working on a whole variety of ways to improve the way we provide quick and simple access to justice in the civil arena. We're having a public hearing on that coming up this week. We made some proposals. The lawyers are not, I think I can say, not to put too fine a point on it, not at all happy with what we proposed. So that'll be an interesting day. Then, pointing in the wrong direction. There we go. This is something we're working on right now. For a long time, we have needed a one family, one judge system in the state of Maine. We have not had enough judges to make that happen. Governor LePage has been very good about helping us add actual numbers to the number of judges, district court judges in particular throughout the state, and we are shifting to one family, one judge for the contentious family cases. You are not much involved with family cases, family law, and that's traditional, that's as it should be. I'm not sure that the public much cares about how people's difficult divorces are going, but you should know that this system is going to tug at other parts of the system. Whenever you shift resources to one area, it may pull at other areas. So in the district court, judges will be handling families, and it'll stay with that judge, that magistrate, that clerk to complete the case, and you may hear it affecting other areas of the system. And for court facilities, how are we doing? I'm talking too much. Now I'm going to talk faster. I won't talk less. I'll just talk faster. Court facilities and security have improved dramatically in the last 12 or 15 years. And I just want you to know that the governors and the legislature have paid attention to how bad it was for the public coming into the courts. So the very first thing we did, it's sort of Maslow, first keep people alive. And the first thing we did was we went to the governors and said, people can walk into a courthouse with a gun. They can get directly into a courtroom and they can shoot people they don't like. They can shoot opposing parties, opposing counsel. They can shoot judges. Other states, Vermont had a terrible tragedy where a guy ran through a courthouse, killed a whole lot of people on the way through. So the governors, all of them since 2002, have each put more money into the system for entry screening. It's like insurance. You don't want to have to spend the money, really. It's not inexpensive. You need human beings and you need equipment. But if you don't have it, you're going to have catastrophes. So I'm very excited to say we are almost at 70% entry screening across the state. We have turned our attention then to the courthouses themselves, and we have a number of much better courthouses. We have a lovely courthouse in Dover-Foxcroft. We improved the courthouse in Holton. You've seen the courthouse in Augusta. It is new, consolidated, clean. There's a place for families to be. We are now working on Waldo County, where there will be one consolidated courthouse. South Paris, do any of you work in the Oxford County area? So in South Paris, that beautiful building on the hill that we all love was not working. And rather than abandon the building, we found an architect who was able to expand that building. The drawings make it clear that it's going to look like that building's been there since 1850. But it'll have all new updated systems. It'll have 3 courtrooms. It'll have a consolidated clerk's office. It'll have great entry screening, and probably most important to the public and possibly the press, it'll have better parking. So we're working very hard on all of that.
Are you keeping the painting? No, there's a painting in South Carolina.
Oh, the South, you mean behind the Superior Court?
Yes.
We wouldn't touch the artist's work, absolutely not. But the courtroom will be air-conditioned, so we can have jury trials when the trains go by. So it's going to be, you know what we're looking at. So this is all very exciting. We're very happy about this. So one of the things the takeaway from all of this is you hear in Maine really a lot of bad things about government and how we all work together. And certainly we've had an exciting couple of years around some governmental issues. But the truth is, behind the scenes, in a non-partisan fashion, legislators and governors have stepped up to make sure the public can get access. Good, safe, decent, respectful access. And I will be eternally grateful to them because they have listened, they have responded. So, we could talk forever about drug courts. I have proposed a wraparound drug court for the coast, which I'm happy to talk to you about. I'm very excited about it. We were, you know, in legislative time, 5 minutes really from a bipartisan and gubernatorial supported wraparound court for the coast, and then the whole session got a little difficult. But we're going back at it, and we can talk about that if you want to talk about it. This is actually, as projects go, relatively small, but for me, very exciting. So I want you to know about it because you may see it in some of our courts. We have a really vibrant newcomer community throughout the state of Maine. And as much as everybody hears some of the negatives about that, people coming in and being relocated perceive Maine as a welcoming and safe place. And therefore, when they arrive, we want them to feel that. We want them to feel safe in our courthouses. We want them to understand what's happening. And as we all know, when English is your first language, it's hard to understand what's going on in a courtroom. So if English is not your first language, you really need help. We've got a whole new system, and Ted has been just amazing at making sure we've got staff who are working on this for more interpreters all the time. But as the community grows, we are getting languages and dialects for which there are no interpreters in Maine, no interpreters in New England. And so what's happened is across the country we have this wonderful coalition of courts who are finding interpreters for the variety of languages and dialects. And that will now be available in some of these languages through video interpreting, which in the first rounds has actually gone very well. So it both saves money. You don't have an interpreter on standby for a language that's not used constantly, but it provides very good, recordable, respectful interpreting in the courtroom. So it's a complex system, and of course you have to make sure that every blue cord everywhere works well, which is always a challenge, but it's going very well. And the American Sign Language project to do the same thing, because if you've watched a court proceeding where American Sign Language is the language of one of the parties, you will see that the American Sign Language interpreters tire because things go really fast in a courtroom and they have to keep swapping out for each other, and sometimes there aren't enough people. If you can bring some in by video, you can really make a difference. Okay, sorry, I'm up on my soapbox about how things are improving. So, let's talk about, we have about 15 minutes, and I want to make sure, I'm going to stop just a moment and please shut the camera down for a minute. I am confident we're off the record, right? So, did you know that if you add one chemical to Diet Mountain Dew, you can create a phosphorescent flare and get yourself off an island? I know that because my physician said, whatever you do, don't drink Diet Mountain Dew. You can see how compliant I am. Okay. Access to digital court records. Now, here is an area where you may have a lot of questions, and I want to answer those for you. But I want to start with my gratitude. Our very first step in trying to figure out how to balance public records and a presumption of open courts with the privacy issues that exist with regard to some court records was to put together the Transparency and Privacy Task Force. You all saw the report of that task force, and I am I'm serious about this. I'm actually very grateful for your input. Some of it was thoughtful and scholarly. Some of it was not. But it was helpful. And it really did help us look very hard at the proposal. So the original proposal, the task force did a lot more than recommend a particular design. They pulled together what's happening in other states. They pulled together a whole lot of the constitutional law. The task force did an enormous amount of work, and they did it very well. What you've seen, however, is that ultimately their recommendation was that we move from practical obscurity, and I know you've all heard that term. The information is in a file in the Madawaska courthouse. It is not particularly accessible, to digital obscurity, where you could not get to the information unless you actually came to the courthouse. And that was their recommendation because they wanted to be cautious as we began. They've seen other courts create some terrible problems by putting everything up on the internet without thought, and they wanted us to go slow. It was a perfectly reasonable recommendation. You did not quite see it as reasonable as the initial recommendation, and we went through a whole lot of analysis to try to figure out whether that would work, and concluded that it would not. So we will not go to digital obscurity, and anything that is public and can be digitized will be available on the internet. And I say can be digitized because you've all seen it. My first trial in the Superior Court, the evidence were 2 fish. And they handed them to me. And I can remember thinking, oh man, Don Alexander must know what you do with the fish, but I don't know what you do with the fish, and you don't digitize them. So there will be issues that in which you're going to have to go to a courthouse to see whatever it is that got admitted. But if it is digitizable and it is public, it will be available on the internet. There may be, and I think the phrase you use is a paywall. There may be a paywall for multiple searches. We don't know yet. We're still working on that issue. And we have endeavored to keep this as cost-free for the public and the press as we can, but we anticipate, particularly for data miners, that there will be costs involved. There may be costs to the press that you've seen, like as in the federal courts. So, step 2, determine basic design. The basic design is if it's digital and it's public, it's available on the internet. And step 3, and this is what I keep getting back to, so you're going to hear me being just a little bit obsessive about this. I think the problems happen between the press and the courts when the rules aren't clear. If the rules are clear and you know and understand what you cannot have, you know how to challenge that, and you know how to appeal it, and we know how to address the challenges. If the rules aren't clear, you get staff that don't know what they can do, you get reporters who don't know what they can have, you get time going by while the public is waiting for information. So, my working theory on all of this is that clarity will help the public. So, the next step, the next step is just basically, you know all of this, so I just wanted, I think you've seen these before. Substance abuse records, domestic violence records, mental health proceedings, those things federal and state law close, are not public records. They will not be digitally available on the internet except to those people who have access to them. And this is what we're going to do. We began our analysis. So we got the TAP report, we made the design decision, we spoke to you many of you came to a public hearing, we went back to the drawing board, and we started designing what the system would look like. We begin with the presumption of open records. We determine what federal laws close the records. We look at the state laws. And in this arena, I have to say, how many of you have served on the Right to Know Committee? 2 people. Well, there's a reason for that. It is detailed and occasionally tedious work, and it is really important. And so we decided that we did not really need to reinvent the wheel. We started with the Right to Know Committee's reports on the various laws that close and open records under state law. And then we looked at court rules and administrative orders that have been in place that you've worked with on particular documents. And by those, I mean you will find that there are administrative orders or rules that say a photograph of an actual child being raped will not be available to the public. Those kinds of documents are addressed in that area. So that's how we began. Then we moved to what I think of as the funnel of decision making, particularly how you create the clarity. So we all know there are case types that are not open to the public. Child protection, juvenile misdemeanors. Public is not allowed in. Those records will not be digitally available to the public. Then you look at documents. So some of the substance abuse evaluations, the federal law makes those whole documents not public, so you determine which documents aren't public. And then you think about specific information. And that's where the world has changed in the past 5 years. And every court is trying to redact and eliminate the kinds of identifying information that allow people to use the courts for identity fraud. So you're going to begin to see people identified by year of birth or county. You will not find mother's maiden name and the name of my first dog in the digital records. And we're trying very hard to make sure that that all works. So if you take those two funnels and you work through all of the various laws, what happens in the end is actually not surprising at all. Here's the basics. We are putting together a single statute in Title IV that gathers in one place all of the other statutes, so there will be references, and so it will say mental health evaluations in civil proceedings are in the category of not public records, and there will be a cite to the statutory provision that says that's not a public record. So we've created this, it looks daunting when you look at it, but you're all going to recognize this because it's what we've been working with forever. And then the foundation for all of that chapter will be existing statutory and rule-based restrictions. All records may have a newly masked area of personal identification, so on that whole issue of identity fraud. And an otherwise public record may contain a confidential document. So you've worked with that previously. You've picked up a criminal file and the clerk will say, I'm sorry, that document, I have to take that document out because it's not public. So none of this in concept will look much different to you. And here's the interesting thing when we got all done with the first round of analysis. Criminal courts are the area where traditionally, constitutionally, and from time immemorial, the public has had access to almost every stage of criminal proceedings. So most of the documents, the proceedings, and the information in a criminal record are open to the public, they will be digitally available, and there will be very little change in the criminal records. And remind me, there's a potential change we have to make in the Criminal History Records Information Act, which is just really odd, so we can talk about that in a minute. Traffic records, there's really no substantial change. What you'll find is the personally identifying information has been removed. You'll get the person's name, month and date of birth, place that the stop occurred, officer who stopped the person, and the nature of the infraction. So you can get that all, public will have access to all of those. Civil records, so car accident cases, contract disputes, a number of the civil records, you will find that there's not much of a change. There will be individual pieces of information, usually documents in those records, where the parties will ask the court to seal the documents. Trade secrets, for example, some very personal medical records, they may be sealed. We're, on that issue, we're creating a clarity in how to appeal from the sealing of a record or the denial of a sealing of a record. So you'll find, I hope, some better information there. The one-day events, small claims, foreclosures, evictions, no substantial changes. But I will tell you, when we go to the legislature, I absolutely expect that advocates for low-income individuals will be urging the legislature to close some of those documents, and we'll all have a chance to talk about the social issues involved. Juvenile records, same thing. We are not proposing a substantial change in juvenile records. If the proceeding is open to the public, because it's a felony, then the digital information will be available to the public online. That is the proposal that we have in place right now, because that's the law that's in place right now. I am aware, and you may have heard some of it at the public hearing, that there are people who are very concerned about having digital records available before there's been a conviction, because those will follow people their whole lives. And that will get us back to the Sharia issue in just a minute. The area where we will have a new approach, the one substantive change where the court system itself is proposing a change in public access, is in family records. So we did a review, the TAP task force helped us enormously there, of other states with regard to family records, and learned that in many states, somewhere I have the list, the court system, when it went digital, determined that family records simply would not be digitally publicly available, because the pain of these family disputes, it is an issue for the individual litigants. It is not a question about what the courts are doing in most instances. So they just don't make them available publicly, period. They close the proceedings. It will look like a child protective proceeding. It's just simply closed to the public. Then other states created a system where for family records, so when I say family, I'm talking about divorces, child support cases, paternity cases, some of the inter-family guardianship issues that are now becoming so big as a result of the sad stuff in the opioid epidemic. Those are the cases I'm talking about. So some states just allow the public to see the docket entries. So we looked at all over and determined that we're keeping in mind that the reason the public needs to see records is to assure that the system and the judges are working appropriately, that things are all being done in a neutral, unbiased fashion. And we are going to propose a hybrid that we haven't seen anywhere else. So we don't know how it's going to work, and we are still working on the documents. And this is the hybrid. Parties to a family proceeding. So assume, where's my handsome husband? He's in the back. So assume that I wake up some morning. See, wave to me. If I wake up some morning and say, all right, 32 years is enough. And I want to, it's never enough, let me just say that. Patience of a saint. Yes, yeah. So I say I'm going to file a complaint for divorce. I would go online and fill in the complaint for divorce, and it would say who I am and who he is, and what we have. We have a house, quite a bit of debt, and some old cars. And we have 2 adult children who no longer, well, that's just a lie, who are no longer legally entitled to support from either one of us. And I would fill out this relatively bland form that says I want a divorce. And he would file his answer, and the case would move on with the documents that fly between the two of us where he reminds me how I don't even know where the kitchen is in the house, and I remind him that there's never been a tool he could not fall in love with, and all those documents fly back and forth. The public doesn't need to know that. Then the judge will enter a divorce judgment that says, you're divorced, here's your new name. I finally get to call myself Gwyneth Paltrow, and I have divided your property, and that will be the end of it. But the public will know that the divorce was completed and that the property was distributed. And if we had had minor children, the public will know that the court did something relatively detailed. There will be check boxes. So the children, there's shared custody, or there's sole parental rights, or those kinds of things will be there without details about the children's needs, issues, etc. So one of the things that, that we want to be careful of is not leaving children with a digital legacy that their friends can beat them about the head and shoulders with. So we're working on the forms. We think that we have hit the right balance between the public's right to know what the courts are doing and the need for families to have some privacy in the most painful moments of their lives. So that's what we're working on there. Questions about that?
Did you say, is the judgment going to be available in the family cases?
The judgment, a judgment. So it'll be a cover judgment,
Yeah.
and then there will be details behind it. So if the children have mental health, who's going to transfer, all of the kind of details will be in a non-public document that the families are free to share if they choose, but the court will not share those details. Okay, so that's where we are. Whoops, I'm going backwards. So here's the process. I'm running over time. You have another speaker coming. Here's what's going to happen next. So you've heard me talking about the fact that this is, our proposal is legislative. Now, some courts have said this is entirely up to the courts, legislature, you stay out of it, we'll make the decisions. In some instances, particularly evidentiary instances, I absolutely agree with that approach. But these are big social issues happening on what I think is an enormous public policy stage, and we are taking our proposal to the legislature because they are the public's representatives, they are the sounding board. So we're going to do something relatively unusual. We will put together the proposal in a bill, an act to clarify access to digital court records. We will post that as we do rules for public comment. You will see that. Keep an eye on the news page for the judicial branch. Give us your comments. Let us know what you think. I know that you're very shy about that, but try to get over it. We will then take that information. We will edit, polish, amend, consider what it is people think will be a problem, and then by cloture we will present a bill to the legislature for its consideration. So ordinarily those kind of bills don't go through this public process first, but we think it's better for everybody if we get talking about what the issues are before it gets to the Judiciary Committee. So we will have, everyone will know what we're dealing with. We will have had the benefit of your thoughts on what we've proposed, and we'll present it to the 129th legislature. I'm sure it will be going to Judish. Judish has all the right to know work, right? So it'll end up right in there, and then we'll hold public hearings. And some people will wish that we will close more. Others will wish that we would close less. We'll have that conversation in public. We'll make the decisions, and then we'll have a system in place before the system goes entirely digital. So we will not have the kinds of catastrophes that other states have seen. So that's the plan. Judy.
And if the committee decides to hold that over, does that put the pilot project off another year?
Judy. We can't. We can't put that pilot project off. We have to get this going. If the committee decides to hold it over, I will have failed, and it will be time for me to retire. hand this to someone who can be more persuasive. We really need to have this in place as we get the final pieces of the system ready. And the system is going in first in the Bangor region. There you go. See? Because we have brilliant people working in Bangor, and we want to make sure it works for everybody. So I'm just, the reason we're working so hard, we worked early with TAP, we're working now, we'll work through this fall, we'll get it to the legislature. I think it will be ready for legislative decision-making when we get there. And my fondest, and the committee has been very good in recent years in understanding when there's a timing problem. So I'm just hopeful that it will all work. So I've answered every one of your questions about the court system and how lovely the Chief Justice is. What can any questions? Any concerns?
Specifically, and maybe Ted can answer this, maybe you're not there yet. Are we going to be able to go into the system and sort by, because, you know, anecdotally, bail is being set at very different levels in different prosecutorial districts. So right now, you can't make those comparisons except anecdotally. So are we going to be able to go into the system and look at, you know, bail for certain amounts of crime, certain types of crime in different prosecutorial districts? Are we going to be able to make those kinds of comparisons?
I think that we are. I think, well, let me put it this way. I think that we are going to be able to do those kinds of data searches to provide you with the information you're looking for. I'm not sure that the public will be able to do what I refer to as kind of a cross-section data mining that the court will be able to do, but the very purpose of creating this digital file is to allow us to give you more information and give the legislature more information. And by the way, we now have a system in place with all of the sheriffs. They tell us every month who's in jail, why they're in jail, what's set. We're looking hard at every single person who's being held on anything pre-trial. And you are correct that Region 5 has some struggles. So here's a question I have asked for years. I'm moving into your next, shut me up if you need me, because I will talk forever. One of the things that has baffled me for 20 years is the fact that in Bangor, the number of juvenile petitions that are filed are proportionately among the smallest in the state. The juvenile officers say that that's because they're very good at diversion. They don't file a petition unless they absolutely have to. They don't think it's good for the youth. We all agree as a policy matter that that is good. So we have these very, very few juvenile petitions. Bangor's jail, proportionately, is overflowing all the time with young adults. So I keep saying to the people in corrections, can you track the kids that have been diverted, the kids that have come into the system? Can you tell us whether, in fact, those diverted kids are staying out of the adult jails? And they can't tell me the answer to that. So we are hoping that some of this will allow us to have more information that will help us make policy decisions about what's working and what's not working. The more information we have, the more we can address the kinds of research issues and resource allocation that's really important.
Good morning and welcome. This is the first session of our Reporters Boot Camp. This is the first of two sessions. This session is going to run for 50 minutes. We'll take a quick break, and then we'll start the second session. So this is Libel, Copyright, and Property Rights Workshop. I'm Mark Mogensen. I work at the Sun Journal, and I'm also a Maine Press Association board member. And I'd like to introduce our panel today. Starting from my far left, that's Matt Kaiser. And he is a recent addition to the Maine community after moving from New Jersey. He has a master's in international sports law. He currently works for Global Sports Advocates of Portland and has dealt with a variety of legal issues, including protecting athletes' intellectual property rights. Matt has advocated in front of the Court of Arbitration for Sport in Switzerland and has worked with clients around the world. Thank you, Matt, for joining us today. Next to him is Lisa Haber-Zettel. She's the Universal Desk Editor for the Kennebec Journal and the Morning Sentinel. Her work focuses on print design and web curation. She has worked in Maine news media for 8 years and is a graduate of the University of Maine. Go Black Bears. She loves ethical editing practices and hates the Facebook algorithm. Maybe more on that later. And to her right is Sig Schutz. He's a partner in the Portland law firm of Pretty Flaherty, and he is probably one of the best things that has ever happened to Maine media. He is a god. For anybody who doesn't know, he is a god. When it comes to things like transparency and open government, he is just so good. To tell you all the things that he has done or accomplished or advocated for would take pretty much this session, so I'm not going to do that. He specializes in First Amendment, defamation, and privacy, state and federal freedom of information, news gathering rights, and intellectual property. He's written guides for members of our profession as well as members of his profession, serves on several government transparency boards, and is often appearing on our behalf before courts and legislature. So thank you, Sig, for being here. And that's it. Please take it away.
Okay. I'm going to be serving as a moderator, basically, for this panel. I'm going to be serving as moderator for this panel. We have a series of scenarios that we run into in the newsroom or in law practices. Our resident lawyers will tell us what they would do from the perspective of representing a newsroom or representing a private client. And if you have other questions or scenarios that you would like to bring up, we'd love to kick it back to you. So did you want to start with the 4 questions you asked yourself about copyright?
Sure, and Mark, thanks for that over-the-top introduction. I was in this same room yesterday presenting at the Maine State Judicial College on public access to the criminal justice system, to the assembled Supreme Court justices, Superior Court justices, and district court judges. Justice Saufley is going to be presenting this afternoon. I would just encourage all of you to attend and introduce yourselves and make sure she's aware of how much you appreciate her being here and taking her time she drove back to Portland, she's driving back up to present to you all this afternoon. Well, these scenarios are being distributed, and Lisa and Matt really did the lion's share of the work, if not all the work coming up with them. So, but I did want to take a minute to just give you some overview or broad, big picture thoughts on copyright and use of images found on the internet or video. And I think, first of all, as you all know, photographs and video are creative works. They're covered by the Copyright Act. And just because an image or video is on the internet, available on Google or on YouTube or Twitter or somewhere else, that does not waive the creator's copyrights. That does not license to use the image. So in general, permission is needed from the creator or owner before any image may be used. Again, just because the image is on the internet does not mean that it may be downloaded, used, displayed, or even embedded on your websites. So I would just broadly list perhaps 4 questions that you might ask before using any image or video. 1, is the image covered by copyright? Just about all are, but maybe there are some old images, pre-1920. Their federal government works are generally not covered by copyright. Some works are put out explicitly subject to a Creative Commons license or another regime where copyright has been waived. Second is permission required. And your primary issue with that is fair use. Fair use is a defense, and if your use is fair, qualifies as fair use, then you can use the image without permission. But that's the second question, is permission required? The third question, if permission is required, then who owns the copyright? In your ideal scenario, there'll be a copyright notice that will give you the identity of the owner. In all other situations, you've got to look at tracking down the owner of that image, which generally would be the person who took the image, not necessarily the person depicted in the image. It would be the photographer or the videographer, or if the image was, the image may have been transferred, the rights to the image may have been assigned, or the image may have been taken, as occurs all the time in the news media. If it's a staff photographer, the news organization owns the image, so the news organization would have the right to give permission. And finally, the fourth question is, did you get permission from the right person? Does the owner, in fact, give permission? And there you've got to confirm the authority of the person who you are asking for permission. You've got to confirm that person's authority to give permission to use or display the image, preferably in writing. So, is the image covered by copyright? Is permission required? Who owns the copyright? And does the owner give permission? Those would be the four questions I would ask anytime you're dealing with an image or video or other creative content. Could be a poem, it could be something else. Before you go ahead and use that in the newspaper, or when you're editing the paper, before you approve that for publication.
Yeah, just on that, it doesn't happen in real life. And so that's where my law firm comes in, and we end up trying to get a cease and desist and get some money out of the infringement.
So don't get your paper sued, is basically. Okay, so I'll just launch into the first scenarios. You have the same list that I do, so you can follow along. You're writing a profile for a local high school athlete. They don't have time to come and sit for a photo, and you have no good file photos of them, so you ask if they can send you a photo of themselves. The photo they send you is good, but it looks like it might be a professional headshot. So what do you do? Okay.
Yeah, I think just setting aside the law, one question would be, is this story favorable to the subject of the photo? Because if your story is a favorable story, then your risk of getting into trouble is going to be mitigated substantially. So, if your profile, your typical profile of a high school athlete is going to be lauding the accomplishments of this person in the community, I think your level of risk at some kind of problem is moderate. If, on the other hand, you're disclosing the fact that this high school athlete has been engaged in some kind of misconduct, and they're going to be looking at any way they can to force you to take down that story, or to issue an apology, or to punish you, I think that's going to drive that could drive your decision ultimately on using this image. I mean, obviously, if it's a professional headshot, the question is, who took the headshot, and do they have authority to allow you to use that headshot? But from a practical standpoint, is this story favorable to the subject? And if it's favorable, you're going to be safe running it. Whether or not it's strictly speaking, you've gotten all the permissions that you might need or have confirmed.
Yeah, exactly. And to go off of that, I mean, our specialty is representing the athletes. So the fact that in this scenario she gave permission to use the headshot on our end, that's completely okay. They can use the headshot. It's then the next step, as Sig referred to, is okay, who owns the headshot and whether or not the newspaper publisher can use that headshot. But from our end, it's clear sailing, just because she or he consented to it.
Right, I think what I was trying to point out, and they've pointed out, is make sure the person you're talking to actually does have permission to give you permission to use that photo. Sometimes it's, you know, if you have a professional headshot taken, sometimes whoever buys the photo, so the family probably of the student athlete would have permission to say, yes, you can use that, but sometimes, and this has happened before, the professional photography company said, hey, I did this photo with the understanding that it was going on the wall of the living room, not in a newspaper, to be sold for money, so.
How do you credit the photo?
It's usually contributed photo. Does anyone else want to chime in with what they use when you have a contributed photo?
We use courtesy photo by, and we list the photographer's name.
Yeah, we've definitely seen scenarios where the photographer demands credit, attribution, and insists on that, and has raised hell when they haven't been credited. Even though copyright law does not require that the photographer be credited. But if you get a contributed photo like this, it's important to check any metadata or anything else, maybe in the name of the photo or anything else with the photo if there's data that would indicate that there's a copyright claimed and who may own the copyright in the photo. So if it's contributed in a file format that would allow that, it's really critical that you check that. And there have been cases where news media or others have gotten in trouble by publishing the photo, omitting credit or attribution when that's been requested.
Okay, next scenario. You're covering a local film festival. One of the guest speakers is a former Disney employee who will be talking about Disney movies. Festival organizers send you screenshots of these movies to use with your article about the festival. What do you do?
I'll say one word, Disney. Disney is like the most aggressive IP. They will aggressively pursue remedies and to protect their IP. I think where you've got an entity like Disney, it's very important to be extra cautious and careful that the festival organizers have confirmed that Disney has given them approval to share these screenshots, or to share these images. I think this is the type of coverage that could very well be fair use depending on what you're doing. I mean, if you're just splashing a Disney character on the page of the paper, listing the festival schedule, that's not going to be a very strong case for fair use. If you've got an image from the movie and you're reviewing the movie or commenting substantively on the movie, that's going to be a much stronger case for fair use, for a fair use defense.
No,
Okay.
he's got it.
Okay. Next scenario, a local family has suffered a tragedy. A third party has launched a GoFundMe account to help them. The third party has given you permission to use a photo of a family posted to the GoFundMe page, but the family hasn't been in touch about the photo. What do you do?
We open this up?
Yeah.
Definitely go for the family. Of course, at times of tragedy, it's hard to get hold of somebody from the family, and the last thing you want to do is deal with that. But then again, doesn't the news value of the photo, we're writing about the tragedy and someone who was killed, and there isn't the news value of that photo give us permission to use that photo despite whatever copyright may come up?
I think, again, if what's the context of the use of the photo? If you're writing a news story commenting on the tragedy, and this would fall into my first comment about, is the story favorable? You're publicizing this. This kind of scenario, it would be important to confirm the authenticity of the photo. So there's a lot of kind of hearsay in this scenario where a third party is giving permission and the family, so you would definitely want to make sure that that photo is what it purports to be, and perhaps do some diligence in the background of that GoFundMe page. It would be horrible to publicize a fraudulent GoFundMe page. All the more reason to reach out to the family and confirm, that the photo is what it purports to be, and that you have permission to use the photo. Now, of course, the people depicted in the photo unless this is they've got this selfie situation, they didn't take the photo. So again, technically, the family that's depicted in the photo would not be the copyright owner. It would actually be the photographer who would own the copyright to the photo. But realistically, it's a family photo. I think it's probably asking too much to try to trace down who took the photo, unless it's, maybe in your first scenario, it's a professional headshot. But, so I think this is pretty low risk overall.
Yeah.
We had this very situation when the little boy drowned in the Andro this year.
Yeah.
And we were really careful with the family photos, because most of the family photos that were posted on the GoFundMe page had the sister and the older brother in the image, and Carl was really good about dropping it down just to the missing boy, so that we weren't getting the larger pictures. And we really stuck with the subject of the story and made sure that not any other stuff, because family photos do have all that kind of weird stuff in it sometimes.
Right, and I think that's maybe a good way to deal with it. If you're only looking at one person in the family, maybe just, because people get less angry, I find, about headshots than they do about, like, here's the whole family that something bad happened to, or like, if there's an aunt in the photo or something, then, I mean, anyone who looks at Facebook comments or comments on news stories can tell you, anytime there's any sort of tragedy, everybody has an opinion about whether or not you're covering this responsibly or respectfully, and usually the answer is they think you're doing it wrong. But, yeah, I mean, as Sig said, as much as we don't want to bother families who are grieving or dealing with a major tragedy, it is important to do due diligence and reach out to them to make sure it's, they're okay with you using that photo. And I think, yeah.
Can I say something else about, excuse the list, the dentist, but about photographs that have to do with tragedies. Another side of it is responders. I'm an EMT and a search volunteer, and people may think it's okay to put pictures with responders. Isn't this great? But those responder groups have their own sort of professional ethic about that stuff, and it's very intrusive to publicize EMS or search or anything like that without permission, because that makes it look like they're trying to, like they have no awareness of patient confidentiality or legal confidentiality or things. It makes them look like they don't care about that stuff, and so it's delicate.
You mean photos of them or photos they took?
Photos of them, photos on scene, or photos that might just even be a file photo, or something that people don't realize there's an ethical side to that as well that's sensitive. Even if there's nothing in the photo that's sensitive, the EMS people or searchers or whatever don't want to look like they don't know that you're supposed to be conscious of this stuff. Does that make sense?
Yeah, is that something that you've gotten feedback on, that people think you're in a photo so they think that you don't know how? Okay.
Yeah, but you sent it to the paper, that the EMS agency sent it to the paper, so no.
Right.
So it's a tread lightly and get permission kind of thing.
Right, so in that scenario, you have a lot of people looking at you going, what do you mean we can't take photos of fires? Can you talk a little bit more about that? Like who should reporters be getting permission from?
Well, there's usually, if it's a big scene, there's going to be a public information officer or somebody charged with organizing the media. If it's a little hometown thing, it's a good idea to just make sure you're only including people in the picture that you mean to be including in the picture, and that you check with whoever, whether it's the chief or somebody, some professional person there, that you're not sort of like, snap, gotcha, because they hear about it from their colleagues, that, you know, something might have looked inappropriate.
That's,
I mean, I think legally, there would be nothing stopping, say,
Yeah.
the photographer from taking those photos. You know, they're not trespassing, and, no, but
Just
you're-
throwing that out there as something to be aware of.
Yeah.
I'm not suggesting that it's illegal.
right, and this is something that's good to think about too. Maybe not as, you know, have in-depth discussions every time you report on a fire or a missing person, but what is legally acceptable versus what is ethically acceptable, or like, you know, can I get away with it legally without being sued? Sure. Is it a jerk move? I don't know. But it's important to ask yourself that question, and thank you for bringing that up, because I don't know that I've ever thought twice about, oh, are these EMS people okay with being photographed, because legally, you know, if you're in public,
Yeah.
we can take your photo. So that's a good perspective to have. Thank you.
I just want to comment on the suggestion that the photos be cropped. I think that is a prudent step to take, and that also enhances your fair use argument, where you've only, you know, if you don't have permission for the photo, you're finding the photo, and you're deciding it's sufficiently newsworthy, it's essential to the story, etc., but you've only used the portion of the photo, or maybe a screenshot of the video, or something like that, where you've taken only it's sort of the least amount possible. You've pruned back what you're taking to what's really necessary to fit your story.
Anything else? Oh, yeah, sorry.
I have a question for you. Is there a case you can think of where an emergency responder would have a good case against having their photograph in the paper at the scene of the fire or an accident? I mean, is there an actual reason that they get a good case for objecting to it?
No, I think you are on safe ground.
Okay.
You know, I think to the extent you want to talk with those responders or get their names or something like that for the image, maybe that would help to get the dialogue going with them about what you're doing and why, or something along those lines.
In most cases, the responders send, allows photos, they put them up on Facebook, and they have no problem with that. I never thought of someone having a problem with that, because it shows what they are doing.
Yeah, the instance that I was thinking of was more a matter of the individual responder sort of catching a lot of flack for people suggesting that they did not go through their chain of command and was looking for attention and was careless about quote unquote patient confidentiality and that stuff, and sort of dumping it on them personally. They didn't do anything wrong, but they still took criticism.
So maybe that's mitigated if the photo is credited and it's clear that that was taken by the news and it wasn't contributed by that responder. That's part of the issue.
I mean, I didn't mean to turn that into a big project. Just be aware that they can be subject to criticism if it looks like they're responsible at all for the picture.
Yeah.
I have a quick question. We provide a lot of photos to the media, but in this case, I used to be a bank security officer, and years ago we had a robbery, and there was a photo in the paper of the teller who had been the victim of the robbery, and we kind of went back and forth, on whether that was allowed or wasn't allowed. So maybe if you could speak to that regarding kind of situations where there are victims, so we can
I guess
advise on that.
my first question as an editor would be, what's the context of that photo? Is it just like we stole a photo from her Facebook because we kind of tracked down her name? Was it submitted by the bank? Was it taken from the bank website? Was it taken?
It was taken in the bank.
In the bank. Obviously not during the robbery.
Correct.
Okay.
Obviously, no. No, it was taken after when they came in to report the story. It was a long time ago, but it still sits with me as to whether or not, that victim had rights to not have her photo taken.
I mean, a bank is a private property, right? Does it count as private or public? Is part of the big question.
Well, yeah, I mean, I don't know, would anyone go into I guess this was a scenario where the reporter or the newspaper sent somebody into the bank to take photos of all the tellers, or one of the tellers?
Yeah, I mean, just photography, the first question would be, did that teller give her permission to have her photo taken?
It was kind of like a span shot, so
Okay.
she was in the photo, so
So-
she was also she had been the one who was.
So was she like,
robber.
it wasn't like,
Yes.
Was
okay.
she ID'd as the teller?
Well, that's a great question.
I'm kind
I
of
think
having.
so, yeah.
I would have an issue with IDing her as that particular teller, but if she's just one of the bank employees in a wide shot, I mean, come on, but if you focus in and, and she is and she is the point of that photo, that's like a good, no. I'm not up for that, but we're just talking, this is where the robbery happened, and look at all the employees.
But if it was a picture of the robbery?
I mean,
Would there be any question that you could?
I mean, yeah, because I think that's newsworthy.
And you're probably getting that from the bank or the police then.
Right, unless you
Unless
just
you're
have
lying,
a photographer who stumble in on a bank robbery, which, what are you doing taking a photo instead of getting down on the floor?
That would be Russ Dillingham.
Yeah. But yeah, I think Carl's right. If it's just, here's a photo of the bank where it happened and the teller is just coincidentally in the photo. But, I think we all agree that generally you don't identify victims of crimes because they already have a crime committed against them. You don't want to make their lives worse unless they specifically agree to be identified. So, yeah, if it was an incidental photo of the bank and somebody just said, oh, by the way, that's the teller who was there, that maybe doesn't need to be in the caption. Okay. Anything else on that? Okay. Moving on with crime. A person has been charged with murder. The police have not provided a photo, but they have provided a link to the person's Facebook page. You find a photo of the person on their Facebook page that you would like to use. What do you do? Do you want to? Oh, Carl's got an opinion.
Well, I
Go for it.
believe that they're not going to give a photo, that they would provide the Facebook link. But
I mean, we had a case like that for
Really?
recently. Yeah, he hadn't been arrested yet, I believe.
oh,
So you're
well,
charged, but not arrested yet.
No.
No. Any other?
I mean, would you use presumably law enforcement is directing you to the Facebook page, so that is confirming that is the image of the person who's been charged, so at least you've got some level of confirmation and you've got the right John Doe.
Does the police department put it up on his Facebook page, the photo?
I don't remember in this particular case. I mean, that would also.
Would it change the?
I mean, that would, yeah, maybe, because it's the police department saying, yes, this is different with the guy publicizing that. This is actually a case we ran into in our newsroom, and my boss said, yes, we can use this photo. We did crop it, so it was mostly just his face. I am not a fan of taking photos off Facebook, so anytime someone says, yes, we can use that, I'm like, no. But, it's when it's your boss. Yeah.
It just strikes me that, like, any Facebook picture, the image belongs to the Facebook person.
Right.
And that one wouldn't think about just looking at, in many different circumstances, without their permission, regardless of whether they were being charged with a crime or just seems fairly straightforward.
my issue is, how legitimately is this person a suspect? I mean, if they're out looking for him, if there's a manhunt for this person, yes, I would do it. I just feel the police seem to be doing this more and more, where they say, hey, we would just like to talk to this individual, just let them know we're looking for him, and I just don't feel like putting that person's name or his face in the paper because the police would like to talk to somebody. But if this is actually a real suspect and we're looking for somebody, and they identify that this is the person on Facebook, and it is, I mean, yes, I'm going to use this photo because there is a public service, there's a news interest, and yes, that person owns that image, but the news interest overrides the copyright.
Yeah, 3 hands, I'll start with the back.
What about if that Facebook photo was taken by a professional photographer?
Yeah.
Professional portrait photography that somebody owns and this person puts it on their Facebook page. Do they technically own that photo at that point, or is it still the property of the professional photographer? And also, I've heard a lot of people say that if it's out on Facebook, then it's public domain and it can't be used. And that's what I said, but it's a misnomer that a lot of people think that if it is out on Facebook, then it can be used. Same with Instagram, Snapchat, and all that sort of stuff.
There were a couple of other hands.
Well, I was just wondering if it made a difference on versus Facebook, if they had a public Facebook profile versus one that they had a closed universe.
Right, and that's something that I think some people on Facebook don't realize that, like, if you set certain things public, it means everybody can see it. In this specific scenario, it was a profile picture, so it was part of their profile that was completely public. But
Yeah, I mean, there are terms of service on Facebook, and it has been argued that Facebook, last time I looked at the terms of service, they had some very broad language about once you post to Facebook, anyone can use it for anything and any purpose, et cetera, and there is no clear case law yet testing exactly how far that gets you. And then you get into if someone really took exception and registers the copyright and actually files the federal lawsuit, and then there's what's our war chest to create law on this? What's our appetite to create law on this? And what's our deductible in our insurance policy? And so that's where you really want to get into the question of how critical is publishing that image for the story. Is this a man? Is this something critical? Is it critically important to inform the public and share the image or not? And how much risk is the newsroom prepared to take when you make that decision? So I would, I guess Lisa, you run it up the flagpole to make sure that you've got protection if you end up on the receiving end of the cease and desist letter. On the question of ownership of the image, a lot of photographers, unless they're quite sophisticated, don't necessarily even have written contracts with the subjects. We saw this recently with a well-known art photographer in Portland, Jay York, if anyone's familiar with him. His position, he's been taking photographs of artists' artwork for decades, and he has no written agreements with any of the artists, intentionally, none. So he has retained the copyright in all these images he's taken for artists for the express purpose of allowing the artists to publicize their own artwork, and then the artists use the images as handout photos. So then you get into questions of, well, is there an implied license? And what's the law around that? And it gets very murky, and there are no clear, bright lines around exactly what the rules are. And so it's a risk question.
Matt, maybe you can talk about if you had a client who was charged with a very serious crime and a news organization pulled a photo from, say, their professional Facebook page. How would you handle that?
Yeah, we'd, I guess, PR is our mainstay, and we always want to make sure our client isn't guilty before there's the hearing or anything. but we make sure that the newsroom, I mean, we talk to the newsroom, see where they got it from, probably send a cease and desist letter and have them come back to us and say, oh, where did we get it, or, you know, this is where we got it from, and have them prove to us that they got it fairly, legally, and then kind of work backwards. But I mean, if it's a newsworthy article, there's not too much we can do. We just try to mitigate what damage is done to our athletes' reputation. Yeah.
Matt, what if we had a situation where a Bates College student who was captain of the lacrosse team a couple of years ago got drunk, broke into an apartment, and broke an old man's hip. We couldn't get a photo of couldn't get the arrest from the jail right away, but we had been given this guy's photo as part of a roster and a media kit, like the beginning of the season. And we knew it was him because the police said he's the captain of the lacrosse team at Bates College, so he was confirmed. What about that? We already have been given permission by the school to use that photo, but now this is a different story than we're using.
Well, I mean, the photo was taken by the school as a professional.
And released as part of its media kit.
So, I mean, again, as long as the story relates to what the photo is being used for, we can't really stop you, other than we'll try to make sure that the information is correct, that goes with the story. Again, we are looking out for the best interests of our athletes and our clients, but at the same time, we understand that news has to be distributed. We probably would talk to you to figure out where you got it from and understand that it came from the Maine or the whatever college, and it was part of the media kit, but there's only so much we can do to stop it or mitigate whatever damage is done. But yeah, I don't see too much of an issue in that case, especially if it was given and part of the whole media kit that Maine had.
I work in a public relations capacity, so reading the newspaper every day and watching the news is part of the job. But the Facebook one, I thought, again, because it was public and Facebook had all the rules, that more or less was open game, but every time there's something sudden happens, like in the neighborhood or something, you see the media, both TV and print, go and refer to the Facebook page. You see it sometimes a clip and use. So it's one of those that everybody's doing it sort of things. So that's what is sort of surprising to me, that it's to learn that it's not really the best practice. It's dangerous. So again, is it how much of a need it is to get the news quickly out, and that's the only picture we have? They just have to wait.
Exactly.
Yeah, basically. True. Also,
Yeah,
question.
can I just go back to your illustration about the artist and the photographer of the artist, and then a scenario, the artist has that photograph of their artwork and they submit a PR, and so you say, okay, is this copyright free? Oh yeah, it's mine, go ahead, use it. Does that in an email, does that email serve as some sort of protection? That gives you permission, that gives us permission to use that photo of that piece of artwork?
And normally that would, give you good level of assurance that you've got approval to use the image. That said, I would definitely check that image to see if there's any copyright notice, any metadata. I would want to suggest checking to see if there's any attribution requested or credit requested when you run the image. Is it just courtesy, or is someone asking for a credit to the photographer? How do they want it credited? And then if there's any reason for concern, like this situation I mentioned, maybe further questions are going to be warranted, because, yeah, technically it's the ownership of that photo is the person behind the camera, pushing the button, not the artist who created the artwork. So I would say 99.9% of the time that's fine, but it's not 100% because of the way copyright law works and the way that a lot of these artists are not attuned to their legal obligations and having signed agreements and work for hire documentation and whatever that is, and So these questions about handout photos, I think, are, there is not a lot of authority on handout photos. There's not a lot of case law, and most of the time that's legitimate, right? I mean, you explain, hey, we were provided the photo, it's a handout photo, this is how we got it, etc. People understand that, common sense prevails. But there are some who've taken very hardline views on copyright law. Copyright law is a strict liability regime. There's no like negligence or actual malice that you might be, would protect your reporting and public figures. It's tough.
And so just to parlay off that, the second to last example that we have is similar to what you were explaining, where you got an agreement from someone else that says you can use a license. So we had a case where one of our athletes, it was a commercial airliner using a stock photo they bought from, or their advertising agency bought from Getty Images. And they said, oh, well, it looks like, I'll just say, a snowboarder doing a trick. She's all decked out in her uniform or outfit, and you can't really tell who it is, but the agent of the athlete knew who that was, remembers where the trick was, where the event was, and immediately called us up and said, listen, we never have agreed to that image. It was a private run, it was a practice run. I don't know where they got this photo from, but they aren't authorized to use it, especially as part of an advertising campaign that the commercial airliner was using, even though they were just saying, oh, come enjoy the slopes to wherever destination they were promoting. They were using our client's image. And so the airliner said, we got the image from Getty. And so I think that's important too, is knowing what contract you have with wherever you're getting your photos from. So all the liability shifted to Getty Images, and it was their problem to deal with, and we had to deal with them to settle it. And we ended up, settling for a couple tens of thousands of dollars. But it's important to know where, what contract is in place, where your license is, and what you can and can't do. And just because it comes from an advertiser or a normal stock photo company doesn't mean that you can use it.
Oh, 2 questions over there. We'll start. Yeah.
Can I tweak this just a wee bit? My most recent position was web editor at a paper in Western Mass. And we often had the local police put up a picture of someone allegedly robbing a store. So it was a video image of a store robbery or whatever, saying, we're looking for this person. Help us find this person. So it seems to me, and sometimes the paper would pick that up and put it online and say, as the story would be, the police are looking for this person. In teasing out the differences between copyright and actual libel, and now associating this person with this crime, how is that, I mean, the copyright thing is one thing, but the libel thing, that's where, those always made me nervous, because yes, it was news, the police actually were looking for that person, yes, there was actual footage allegedly of the crime, but we were clearly associating that person with the crime in the act of reporting the police were looking for them, but we're also doing a public service because we're looking, so.
Right, yeah, I think a lot of that would boil down to, and other editors and reporters can chime in with how you report it, like in the actual story and the photo caption. I think if the police are releasing it, and it's probably, I'm guessing, a security footage, yeah. If you're saying the police are looking for this person in connection with this crime, and you're not saying the police are looking for this person, and it's a robber, and they're dangerous, and they're gonna shoot, that's where you want to be very, very careful with wording, I would say, and if your police say, officials say, allegedly, and that, I think, legally would keep you from getting into too much trouble. Does anyone else want to chime in on that?
I was going to go back to Matt on his scenario with the airline and ask if your position would be any different if it had been a newspaper publishing a story on some bobsled competition that was due to take place at Sunday River.
Yeah, I mean, it definitely would be different just because it's more of an event, but and in a newsworthy event, with regards to our specific client, if they were using our client to draw attention to the news article and other details of their newspaper, we would argue that it's a violation of what's called the right of publicity. And right of publicity in general terms is unauthorized use of an athlete's name, image, likeness, other form of identity. Defendant benefits from it, and they never got consent, and then there's injury. So we're a lot of the issues that we deal with is involve. I guess what I find fascinating is the Twitter and social media sphere, and if we had several issues after during the Rio Olympics, one of our clients won several medals, and whether or not posting from these different companies saying congratulations so-and-so, we're very proud of you, is in itself either a First Amendment issue where they're allowed to say that, or the way we look at it is it's a form of advertisement because people can click on your Twitter handle, your Facebook post, and get to whatever website or things that you're selling. So you're using our client, their celebrity status, their reputation, to draw attention to your specific tweet, to your specific post. And we find that we try to get as many of those taken down as possible. And then, again, if they have lawyers like SIG, they probably will fight back and have a great argument as to why they shouldn't be taken down. And but a lot of people aren't as sophisticated, and they hear from a lawyer and immediately take down the photo or image. So yeah, that's just a lot of interesting gray area that we deal with and try to recoup money for our client as a result.
So if you had, say, like it was, say, a local athlete or an athlete from Maine or who practices in Maine, because we have, athletes who practice here for skiing and such, and a photo that we did have permission to use, probably from the Associated Press, and link to an article specifically about that event they just won, would that be okay, or would you say, hey, you're promoting your brand using my client?
Of course, we'd always try to say you're promoting your brand. Yeah, no, I think, again, a lot of it is gray area, how much risk you want to take, how much is associated. And with right of publicity, it doesn't necessarily need to be a celebrity. It could be Joe Schmo and a local high school athlete where they're using their image to draw attention and make money, or it doesn't even need to make money, somehow benefit whoever's using it. And then whether or not it crosses into fair use or First Amendment rights, that's the battle that we have to face most of the time.
Okay, do we have time for one more, or?
No, time for one more.
Okay, one more, real quick. So we covered several of those, I think, scenarios with our discussion. Do you have a favorite? Do you want to?
I think the badminton one.
The badminton one, okay. After the World Championships of Badminton, you go up to speak to a bronze medalist. You turn on your recorder and approach him. Before saying a word, the athlete sees your newspaper's name, the Net News, on your press badge and immediately blurts out, "Dude, I read the Net News all the time. It has the best articles ever." Caught by surprise, you thank him and then proceed with the interview. Later, after listening to the interview again, you think about using the athlete's quote regarding how much he enjoys your newspaper in an advertisement for your newspaper. Is this okay? Anyone got any ideas? No one wants to chime in? You want to chime in? Sure.
I mean, it's kind of evident. I mean, the client athlete would agree that whatever interview and what they've said on the interview you can be used, but whether or not they agree to the beginning part is a different issue. There's cases on whether or not definitely using the exact quote or exact voice recording on, I don't know, radio broadcast or on on top of your webpage, we would try to take it down immediately and seek compensation. But there's other cases where if someone else, if say he's known for saying dude or something catchy, just the fact that another agency or article or some publisher uses that phrase, we could say that it's directly associated with him, and that's associated with his likeness and image and overall reputation, and try to take it down and get, again, compensation as a result. Again, gray area, it all depends on the facts, and as the law classes state every time, it depends. So, yeah, no, that's all I have.
Yeah, I would just say, this gets into where you start talking about the advertisement. I think it's going to be much harder to talk about any kind of fair use there. And then you directly can try, essentially using the athlete's comment to endorse the paper and to sell subscriptions. And so my recommendation, if this were to come up, would probably be to, discontinue and, try to make amends or just work things out. I think, as Matt, you mentioned, your athletes are concerned about their reputations. So they're probably not going to be. I hope would be reasonable to deal with if it's a reputable news organization that's just misstepped or made a mistake. But maybe you can comment on that and how much how those conversations go with the athlete or the agent, and what considerations go into the mix when you decide whether to pursue something, how aggressively to pursue it. Something's taken down, is that good enough? We need to take it further. Why or under what circumstances?
Yeah, so we always try to reach a resolution with the opposing party, whoever violated our client's trademark or copyright. Again, it depends. Michael Jordan's law firm or legal group pursues everything. They've gone to China, they've gone everywhere to make sure that only his sanctioned name, use, image, likeness is allowed, and anything that may even remotely violate it, they'll pursue it. With our clients, they're not as aggressive. Some things piss them off more than others. So we had a client, actually we're dealing with it right now, where they are hired by a current sponsor, say it's a badminton racket club, and they were formerly sponsored by a competitor. The competitor put on Facebook, something motivational for their followers, saying, wake up every day, give it 100%, and then they had a cropped image of our athlete from the basically torso down, where it was pretty evident it was our athlete and there was no issue. They only kept it up for 1 hour. And they realized they made a mistake and took it down. But our athlete's current sponsor found it and said, listen, we're paying you money to sponsor you. We can't have competitors using your image. So we're in the midst of dealing with them, and they said, we admit it, we violated your client's right of publicity, we'll pay, even though it's only up for an hour. So it all comes down to how much money you're willing to negotiate back and forth. Again, up for an hour, pretty reasonable as to where the final number comes in, but if it's up for days, weeks, the number keeps growing, and you have a negotiation and tactic on it. But most of our clients, compared to Michael Jordan, don't pursue it as hard. And it also depends on who violated it. We had one where it's a mom and pop greeting card, maker, and they sent our client's baby a happy birthday 1-year-old card, and they had a photo of the mom and the baby, and she put it up on her website, and our client and his agent came to us and said, this is, we didn't give permission, yada yada. So we had aggressively went after the mom and pop card maker, and it turns out that the wife gave the permission. So there's a chain of custody, or a process that now, after that incident, we take a step back and realize, all right, come on guys, we need all the information, talk to everyone before we make ourselves look bad, going after these lower mom and pop stores.
I know we're almost out of time, but I guess I would maybe throw it back to you all on the rebroadcast issue of how aggressively you pursue perhaps others who may have taken your image or your lead, perhaps, with, and republished it on their website or whatever.
We're pretty aggressive because it just pisses me off. And I actually just on Thursday sent a bill to USA Junior Hockey Magazine because they used our photo and our story without any attribution at all under a different person's byline. So no conversation there, just you're getting a $500 bill and we're gonna make you pay it.
Right.
So I'm glad you brought that up, saying, because I think we have to be aggressive about making sure people don't take our work too, because it diminishes the value of what we do if we just let it go.
Very true.
Yeah, and Facebook works both ways. People will grab our stuff, especially those of us behind the paywall. Oh yeah, you can't read it, here's the story.
Do you get people doing that in comments? I've heard from other applications. I haven't seen, I think, on our site, but.
It hasn't happened as much recently, but for a while it was constant, and there was the, people in the comments would post it. That's died down, and there was a repeat offender who made his own page and would repost our stories, and Facebook shut him down twice. That's the other thing. Once you go through the hoops, Facebook is very, very helpful in that.
One question, one comment. If the back to that scenario you just got me clear, if the sports reporter was reporting this as sort of like a column approach, I don't see anything wrong with repeating the way that interview started. It was on the record. The reporter was identified as a reporter. So she said it was, it was with delightful surprise that, he said this. And likewise, depending on the flavor or the design of the publication, to use that in the headline, because it was on the record. So I could see if the advertising department then said, okay, let's take this and turn this into a house ad, let's paste this all over Facebook. That would be crossing the line. But do you agree that as part of news content, okay, that's the way to get an interview?
Yeah, I agree with that.
Cool?
No, absolutely, absolutely. I mean, we look at it, how is the newspaper trying to monetize our client, and then whether or not it's newsworthy, which of course it's on the record, it is. But if they then try to use his slogan or way to just draw attention to their Facebook page to entice people to buy the subscription, we would argue that you are violating our client's right of publicity and using his celeb status as a way to make money for yourself without the news.
But I think given our panel, which is a combined, I would say, more than 100 years of institutional knowledge, we're going to call it graduate level copy editing, so very quickly, that was a great preceding panel of the fear of God and me concerning images and so forth. And I think we can carry that conversation through to other really important things. And copy editing, is one of the most fundamental basis to what we do, and I think to the integrity of what we do and what we put out there, how we gather news and how we present the news reflects back on the whole industry. So I think what we're going to talk about is of utmost importance. We have an esteemed panel here, Mary Domater from the Sun Journal, Scott Haida from the Ellsworth American, and Carol Semple from Portland Press Herald. So really quickly, I'm going to give a bio, and then we're going to launch right in. So, let's see, Carol was a reporter in Rhode Island, New Hampshire, Maine, won awards for reporting. She was a city editor for the Journal Tribune in Biddeford in the 80s and has been with the Press Herald since 92. Scott, 13 years as a copy editor at the Ellsworth American. Began editing in 2005, and let's see, worked in Westchester, Pennsylvania. Okay, and Mary, 1970s, started your career and started as a nurse, nursing school, said it wasn't for me, and started in the 70s at the Sun Journal as a proofreader. So, like I said, 125, 130 years combined experience. So, the first well, I really wanted to know what you guys thought about what the role of the copy editor is in this day and age. How has it evolved? And your vision, what should it be in the future? And I'm going to hand over the mic, I think, over here.
So, who wants to start? Let's start with Carol. Okay. Is this mic working?
I can hear you.
Yes, everybody can hear me. Okay. I know our time is short, so what I did was I just jotted down, going back 30, 40 years, what a newsroom would look like and my impression of the way it's evolving today. And if you look at the way a story came through the newsroom 40 years ago, you had a reporter, you had a rewrite person, who was the person who took the copy that the reporters were phoning in, because there was no phones. You had the city editor, and the layout editor, the copy editor, and a proofreader. So the copy editor fit in this huge complex of people who would take a story from beginning to end. Today, and I think maybe not so much in Maine and maybe not so much in small papers, but I think the evolution of the industry is such that all of those roles are getting rolled into one person. And the reason is because the stories are going online first. So if you think of the enormity of what I just described in terms of the reporting, and then throw social media in the mix.
Yeah.
So it's all those roles that used to be handled by a group of people, plus the social media role, rolled into one person, and I would argue that that is the copy editor of the future. And they're not going to be copy editors, they're just going to be journalists. So everybody who has filled any of those roles is going to have to learn all the other roles and get very good at them all, and we're all going to have to become super people. And I think that's the way, I think that's the evolution that I see, as crazy as that sounds. That's it.
I would agree with that 100%, but I would also add to that a copy editor is also not an encyclopedia. We need help of the things that we can, that we can do our best to make your stuff look good, but we also need help with, getting the right information, right spellings. There are things we can't control that we rely on the reporters to, and it all works well into one, goes into one big package. So it's a joint effort, I guess, is what I'm trying to say. We can do our part, but we also need help to make it the best it can be.
I think Carol described it very well, and thank you for that, Carol. First of all, I'd like to ask, how many here are reporters? So we do have a few reporters, so that's great. First of all, I love my work. It's very, very challenging, but I love taking something that needs some polish and some clarity and putting it out there for our readers. Number one, I work for the readers. I want our information to go out, I want it to be timely, and I want it to be accurate because our credibility depends on it. I feel very passionately that our job is critical to our nation as a democracy, that we provide the correct information, and that's very important to me personally, especially in this political climate that we're in. So I wanted to get that out there. Our only job as a copy editor is to make reporters look even better than they are. That's our job. We get no awards at an MPA conference or any other place. And that's okay, because the satisfaction I get from doing my job every day and upholding the principles of the Sun Journal or any other news organization that I might be involved with is my reward. And I take it very personally. So The challenges that I find since I started copy editing, I started out as a proofreader in the days of hot lead type. It's changed tremendously. We've had so many technological changes, we've had so many staffing changes, we've had so many downsizings where we do more and more things that we weren't, when we first started doing this job, weren't intended for us, but that's the reality of it. And so we do it the best that we can. My biggest challenges in this day and age are instantaneous publication. So we get a story in the morning and it gets a read, but it may not get copy edited, and it's online. I find that very challenging and a little nerve-wracking for us, because if we want to stay accurate, and we do want to stay timely, but we also want to stay accurate, that's a challenge for me to see us publish things. It's instantaneous. I mean, we used to send the hard copy, you used to send the hard copy in and we would edit it, and then it would be put into paste up, and then it would go on a page, and then it would go to the press, and then it would go to print, and then the public got it. Now we push a button and it's around the world like that. That's huge, huge. So that's, the instantaneous publication is something that we are still grappling with. Secondly, for me, the challenge is IT. I'm not a tech person, I'm a word person. So I've got to learn different computer programs, I've got to learn the system of how it gets up online, how we change it online, how we take it offline, and all of those other technological IT issues. And it's a completely different language for me. I don't know the language. I don't know about polka dots and all this other terminology that's spinning in the newsroom right now, but I don't think I have to learn it at this point. Somebody else will take care of that. Maybe someday I will, but I will probably be retired by then. That might be something that pushes me out the door. But so the IT part of it is challenging for copy editors, I think, because our focus is on the words, it's on the content, not so much the manipulation of the machinery. And thirdly, I would say the challenge is the social media. I'm not a social media person. I'm not on Twitter, I'm not on Facebook, and so there's a whole different language on social media, and I run into it all the time now, and I feel foolish, but that's the way it is. I was editing something this week, and there was a word in it, squee, S-Q-U-E-E. And I thought, somebody messed up here. And so I left it, and I asked our chief copy editor, I put a question on the story. She said, "What's your question?" I said that word, and she said, "Oh, that means squeal, or it means something on social media." Squeal is not spelled S-Q-U-E-E. But anyway, she said it's okay. So I've got to dig out an Urban Dictionary and get myself up to speed. That's a challenge. That's a challenge for this dinosaur. So those are my three challenges. The instantaneous publication, pushing a button, and electronically that thing is going around the world like that. It didn't used to be that way, but that's fine. The IT challenges and the language of IT, and then thirdly, the social media language, seeing that in copy now, and not understanding everything. But that's a learning curve for me. So those are the changes I see that are challenging for me.
So in the old days, as a reporter, you'd write something and you'd type it out, and it would go to the copy desk, and it would come back and it'd be all outlined in red, right? And so your brain would get trained into what was AP style or whatever manual you were using. We don't have that anymore. And I work at a small online publication or outfit in Camden, and I tell the writers, read aloud what you've just written, and does it make sense, read aloud, and check the AP book, and beyond that I'm like, I don't even have time to mark it up. How do you three essentially train reporters. With copy editing, how do you get it into their brains, I guess?
I send out notes,
Do you?
and I do them as I think the challenge in newsrooms generally is going to be training, because we don't have time anymore. We can't just pull people out and do News 101. So what I just did on my own, because you'd end up fixing the same mistakes over and over and over. So now I just put out this little, it's random. When I feel like putting it out, I'm putting it out, and I call it Copy That, and it deals with one issue, and I do it as one bullet point, because attention spans of time are very short these days, and I just deal with one issue and say, this is what I've been seeing lately, this is why it's wrong, do this instead. I mean, I think we have to be proactive, or we're going to be banging our heads against the walls. And the other reason is I try to pick things that are really important because of the instantaneousness of the stuff going out online. So, you know, the big thing is to check people's names. You have to make sure you have the right person. You know, if you're going to send this out online immediately, you better make damn well sure you have the right person, the right company, the right street. And these are things that in the old days we had time to check, and we don't now. So for you reporters out there, I'm very glad you're here, because more of it is on you than it used to be. We can be a backstop, but not like we used to be. So you have to get it right. And if it means you only write 2 sentences initially, and that's all you can be sure about, then give us the 2 sentences that are absolutely right, and save the rest for later. You know, to go online, put the 2 sentences, and then we work our way through as we're sure what we've got is right.
So do you find that works, to send out like a weekly Copy That?
It depends on the person, and one thing I've come to realize is that not everybody is a detailed person. As a copy editor, that's a frustration, but as a person, you have to accept that not everybody pays attention to details. And that's fine in a reporter, because they have other skills, so you make use of their other skills. But, I mean, I sent one out a couple of weeks ago about polling. Polling drives me crazy because people don't understand the statistics behind it. So they'll say, you know, the poll, you know, the margin of error is 4.3%. No, it's 4.3 percentage points. And you seldom meet a reporter who makes that distinction. And I got a copy over my desk the next day that had it wrong. So, does it work? No. But maybe somebody read it.
I think it's a little different for me working at a smaller paper than the dailies. With me, I try to do one-on-one as much as I can when I, you know, see something a reporter should, you know, in a reporter's story that should you know, be better, whether it's wordy lead or punctuation or little things. Pronoun disagreement's a big thing with me. That's one thing we still haven't seemed to master in my 13 years is our pronoun agreement at the Ellsworth Americans.
Yeah, so let's talk about that real quickly, because I don't understand the pronoun of they now, and I know that we're getting into the weeds here. The copy editing is the weeds.
I think it's just good English. I mean,
but to say you can use they to apply to a singular person or a male or female?
No, my copy does.
It's in the AP style one.
Yeah.
Wait for it.
Wait for it.
As far as what do I do to train reporters, I do send out emails from time to time, but less and less because I just don't have the time to do it. We've been short-staffed on our desk for a while. But I do try to do that. Karen Walker, our chief copy desk editor, has done little tutorials from time to time, and she kind of ran out of time to do that too. But I think that's a great way to send an email around to the reporters and say these are some common things that we've seen, and so that's one way to do it. But I want to say that reporters are under as much strain as we are to get the news. I mean, there is a real competitiveness in our industry, especially with the web, to be the first. But I appreciated Scott's note when we were preparing for this. He said that he's not going to sacrifice speed for accuracy. And I think that's the correct position to take. But reporters are under a lot of strain too to get the copy and to get it to the desk. We've all got deadlines, so I understand that it's not going to be perfect, and neither is the copy editing going to be perfect always. But I would strongly recommend that reporters read the edited versions that are published. You will learn a lot. Compare what you wrote to what came out, and you will learn a lot from that. When we had someone new come on the copy desk a while back, I took the responsibility of training, and so I would take their edited versions of the stories, mark it up, give it back to them, and ask them to keep a file. So that's another thing that we can do to help train the people in-house, is to show them the way that we do things. I would also, and maybe this is coming up later, push the AP style book. I know you're under deadlines, you're under pressure to do your job, but that is the Bible. You will avoid a lot of mistakes and be a better writer if you will use the AP style book or the dictionary. A couple of hints I will give you is when you use the AP style book, there are probably things that you're going to go back to more often than others. So what I've done in my style book is I highlight those things in yellow so that when I open the page, boom, it's right there. I don't have to look down the page. And I do the same with the dictionary. There are words that aren't in my brain all the time, so I'm all constantly going back and looking at them, so I put a yellow highlighter on that particular word, and so it just saves a lot of time. So those are some little hints. But I feel like as copy editors, we sometimes beat up on reporters. That's not what we're trying to do. We're trying to, as I said, make your work look even better than it already is.
And Carol, I think you summed it up pretty well. In this day and age, we're all reporters and editors and photographers and copy editors and production. So it really is vital that we figure it out and pay attention to the rules. I mean, because there are rules, there are systems and rules, and a lot of things were blown to hell over the past 15 years, but it's our responsibility to kind of bring it back, bring it back, bring it back. One of you wrote about the fundamentals, and you said don't parrot police, and I was really curious about that, and I can't remember who responded. That was you.
That would have been me.
Yeah, I think that is.
You said don't what?
Don't parrot the police. When you're writing, I guess you're writing your lead, or you get a PR, you get
crime
some
stories in general.
Yeah, but can you elaborate on that one, because I'm really curious.
I think in crime stories especially, you have to be very careful of the language. You know, I guess the classic case would be murder. Murder is a crime. If someone is dead, it's not a murder until somebody has been convicted of murder. But the police might send something out that say, you know, so-and-so was arrested for murdering such and such. Well, the police have then told you that a crime has been committed and this is the person who did it, when in fact you have an presumed innocent suspect, and you have a homicide. You don't have a murder yet. So that's an extreme example of it.
But that brings it back to libel too.
And it brings it back to, and if you look at the lesser versions of that, the lesser extreme examples of that, it comes down with it. Even in terms of the police have incredible power now through the media that they never had before. And in a way, they feed us this stuff, and we gobble it up, frankly. They're sending us the photos, they're sending us the mugshots, they're sending us all these details that we used to have to go pry out of the arresting officer before. And we eat it up. One example is I got something across my desk, this was probably 2 years ago, when the police were really getting into the social media. They had access to all this stuff. And it was a mugshot, and it was when they really discovered that, people's mugshots were not them at their best. They were all twisted. Their hair was a mess. They looked drunk. And they were basically making them an object of ridicule. And I got this story, and, it came in through the police, so the reporter dutifully typed it up and handed it to me to post online, and it was a shoplifting case. And I thought, we have never reported minor shoplifting cases before. why are we doing it now? And it turns out it's because the police are just churning this out, so you have to step back and ask the question, are we now going to start reporting every time somebody lifts a candy bar? And are we going to start putting these people's mugshots out there? And so we had a conversation in the newsroom and said, no, we're not doing it. And so you have to always be vigilant now, because the police have this power to push out this very tantalizing content.
And is that a newsroom discussion that you have with the editor of we're not going to use the mugshot, or we're not going to use mugshots, period?
I'm talking specifically about the
shoplifting.
The shoplifting. We're not going to run the shoplifting stories.
Yeah.
We ran a shoplifting story. In fact, I think it came from the KJ about this dragnet that they were doing. You know, they had a lot of shoplifting problems, so they were cracking down. That's a legitimate story. There's a crackdown on shoplifting. That's different than Jane Doe had a bad day, stole a loaf of bread, and here's her mugshot.
Right.
So mugshots, we do run mugshots. And we held back for a while on some of the more extreme ones. And, you know, I mean, the media, we're all whores. I mean, let's just put it out there, honestly. You know, if you have a mugshot, I'm sorry, I shot. I'm thinking of the recording. Don't play this back to my boss. You know, you have a mugshot of somebody, they don't look their best, but, you know, you're looking at your Twitter feed and everybody is posting it. And you reach the point where it is out there so much. What are you going to do?
What are we going to do?
I mean, what are we going to do?
Do we temper it?
Do we temper it?
Are we in that role now? Yeah, are we in that phase now, tempering it down?
I don't know. I don't think we are.
Not yet.
Scott, were you the one who was talking about, did somebody have a question?
I'm sorry, just an addition. I wanted to say more about parenting police.
Yeah.
Those are some of what you said are the big deal libel issues, and that was a really good point. It's also jargon in police blotters, and I have my 3 favorites that come out every week. A deer or a raccoon is shot, the officer dispatched it. They didn't dispatch it, they shot it. A 3-year-old female was carried off the hiking trail. No, a baby or a toddler or a little girl was carried off the hiking trail. What's the third one? Male juvenile as a teenager. But anyway, so it doesn't, I know, the person was transported to the Hancock County Jail.
That's a good one.
So those are things that's important for reporters and editors to remember, that our readers read news, not police documents, and it's our job to make one out of the other. I just want to get back to the murder example. I was surprised when the New York Times did that big story on Trump and his taxes. They kept saying fraud, like that he had committed fraud. It just jarred me, because I was like, well, how can a newspaper reporter conclude that he committed fraud? Because it seems to me fraud is also, there's
It's a crime. Yeah.
I mean, it just seems like they got a lot of I don't know. Did you?
I can't answer for the New York Times. I mean, I don't know. I don't know.
In your mind, is there a difference between fraud and murder, or is it really? I mean, I know there's a difference.
There's a difference between
right, but
having been convicted of a crime,
right,
and being accused of it. That's a huge gulf.
Yeah.
Yeah, I can't speak for that.
Yeah, I think in the New York Times case, I read most of it, it was a very long article. But they were very careful to cite like financial lawyers and accounting experts, and it was, all of the fraud accusations were basically attributed to them. So even if they had fraud in the headline, the story said, you know, looking at these documents that we have pages and pages of, that's like, you know, fraud according to these people. So that's kind of a way to hedge it if you're worried about the libel thing, is to, you know, attribute the accusation to someone else. Yeah.
Eva, did you have a question?
The New York Times, in a story about my community, called all of the spruce trees pine trees, as did Outside Magazine several years ago. You should know better. you mentioned the difference between homicide and murder technically, and the difference between percentage and percentage points technically. And we all have our little pet peeve thing that, you know, our technical detail that we know about that a lot of people don't. And so there's a difference between the common usage English and the really truly proper English that might only be known to somebody who has an interest in that topic. How much do you guys as copy it right? I mean, you can't be in a position of saying, well, we already know everything about the English language and it's our job to fix the reporting. You've also got to be in a constant sort of continuing ed mindset, I would hope, trying to expand your own knowledge of maybe specialty and occupational terminology and different sorts of fine-tuning of the difference between the common usage word and the really, truly, technically accurate use of the word. Is that sort of part of your world, or do you sort of feel like, well, it doesn't matter, nobody cares, the common usage is fine, we can call these spruce trees pine trees because who cares? Well, in Maine, you know, they're not the same thing. So, you know, I realize there's a sort of a pick your battles, how much do we have time for this, but do you sort of feel like you need to be in an ongoing learning position yourself?
I love Google. I mean, we research as much as we can. Try to get it right.
You don't know what you don't know, so you don't
know what you don't know, but I've always lived by the maxim that every word counts. Every single word counts. So don't give it short shrift just because you want to be imprecise. If you need to be imprecise, then do it honestly. You know, call it a tree. That's my feeling.
Yeah.
I would agree with that, and I think one of the things that I have enjoyed so much about being a copy editor is that there's always a learning curve, and so hopefully you don't get stuck in the same place, but as a copy editor you have to know about politics and science and education and criminal justice and medical issues and the whole gamut of what life entails. And so as you're reading stories, if you don't know, you go to where the answer is. And you do the best you can with what you have to work with and the time that you have to work with. But there are a lot of things that it's just a whole education being a copy editor if you do it right. You're going to learn a lot of things. And in my brain, there's a lot of minutia because I'm confined to a certain geographical area with certain aspects of life. So there's all kinds of minutia, but it serves the newspaper well because I have institutional knowledge of the places and the people and the history and the road names and the route numbers and all of that sort of thing. And so when we get new reporters in, which we do pretty regularly, it's good to have somebody in quality control on the desk who can say it's not Route 27, it's Route 26, and it's not Gray Street, it's Gray Avenue, with those kinds of things. They're small, but they lend they play to our credibility if we get it right. Because I think one thing that I hear when I hear people say, you know, there's mistakes in the paper, it bothers me because somebody didn't catch it, and if they think that we've gotten the route number wrong, which is so out of whack, well, can I trust the rest of the information? That's what it leads to, lack of trust in our ability to get it right. So I think we try very, very hard to get it right because it matters. It matters.
It does matter, and I just want to relate this one. I was talking to an attorney in Camden the other day. I was talking about, I've got this great copy editing panel. We've got Portland Press Herald copy editor and the Ellsworth American and the Sun Journal copy editor. And she goes, whoa, those are really highly regarded papers. And I'm like, yeah, they are. And so you're absolutely right. You were setting the tone for what we're supposed to be and what we're supposed to work towards, I think. And sort of that, like even your point about the ongoing research, yeah, it's is constantly ongoing, and AP is constantly updating and to reflect where we are. Scott, you had maybe a point about that, but I'm looking at my watch. You had a thought about the leads, and yeah, and I think those are important because that's how we talk to the
Basically,
reader.
don't try to say it in one sentence if it can be said in two. I was reading a lead out in the lobby this morning, looked like it was about 40 plus words. Could have easily been, just get to the point. That's.
But how do you tell the reporter? Like, do you send something back, like, or is it, please read how I've edited your story?
Unfortunately, I'm guilty of just going in and fixing it myself.
Yeah, so
I really I should take more initiative with my reporters. In
So,
that regard, so.
of you reporters, do you look at what, after you've written something, do you look at how it's been edited? I'm just curious. I mean, do you say, oh, geez, that's really cut down?
It's not necessarily cut down, just made a little punchier, streamline, perfectly.
All right.
At our paper, when we make a significant change to the lead, we're supposed to call the writer and email them the new lead and make sure it's correct and whatever, so that we get it right. So we try to do that if it's a major event. What I find sometimes is, and I had an example of this, it was Wednesday night, the lead sentence was actually the next to the last paragraph in about 15-inch story. You know, it got to the point where the second to the last graph was what action the board took on the measure. We started out with, they discussed this thing, and then we get down, oh, they've already made a decision about it. So I say to writers, whatever action was taken at the meeting, put it at the top. And don't do it chronologically. If the most important issue was that they decided to buy a $250,000 fire truck, put that in the lead, even though that might have been the last item on their agenda. Try to make your leads no more than maybe 35 words, 25 to 35 maybe at the utmost. I had one in a PR piece Wednesday night that was almost 100 words long, the lead sentence. It was, wow. But that was someone from a PR person. But anyway, yeah, the leads are, that gives the reader a reason to read the story. That's what you want. You want to draw them in. Don't start with the board discussed a personnel matter. You know, draw the reader in with that first lead sentence.
And Mary, could you just segue into the nut graph, because that's the second most important thing.
Yeah, this is when Linda sent us our invitation to be on the panel. She asked us to give some feedback on things. And so one of the things I see in copy a lot is, and I call it connecting the dots. Probably we have all seen those pictures that you draw when you connect the dots, so that when you've got all the dots connected, you see what the picture looks like. And in a number of our stories, too many of our stories, you have a sentence and then you have another sentence and you haven't connected. What does this sentence have to do with this one? Or it's, you know, it could be any place in the story. I'll give you an example of what a nut graph would be. So we had a story about a developer who was going to begin clearing a spot that he had already started working on 2 years before. He was clearing a spot for a hotel. But the story never mentioned the hotel. It just mentioned that they were back at the site and were going to start clearing it. So I was obviously familiar with the story because it's one that we've been running pretty often. So I called the writer and I said, we need a nut graph. We need to tell the person who has never read about this issue before what is going on. What's going on is that they presented a proposal to build a hotel 2 years ago in 2016, and they stopped the project. Why did they stop the project? The story didn't tell me. They stopped it because they didn't get their permits and they didn't get their financing for 2 years. Now that they've got their permits and their financing, they're back to clearing this spot and they're going to start moving forward. But the reader didn't know that. The reader just knew they were clearing a lot for some reason, and it's been 2 years in the making. Not that they were gonna build a hotel. How much is the hotel? It's a $5 million hotel. That's a big deal in any small town in Maine. So those are the nut graphs. You need that background information. It can be one sentence, but you need to connect the dots for the reader. Why does this matter to this down here? That's a nut graph.
And always thinking about the reader.
Yes.
As opposed to each other, right? Opposed to the competition with it.
I think so.
I want to just agree with what Mary said. It's really about knowing how to write for your audience. You really need to write for a general audience. You're not writing for a board of directors. You're not writing for a trade journal. It's people who go into a story having no background in it at all. And that's really important to remember who the audience is, and the audience is everybody.
So we have just a couple minutes. So I wanted to go over the common mistakes that you all are always fixing. Do you have like the top 3 or 4 that just jump to mind?
Over-capitalization. People who will capitalize anything.
Like she was vice president.
She was the vice president of the bank.
Right.
Vice president.
Okay, anything else?
I would say get the names right. I think I've said this before, but beyond that, if you're a reporter, develop a technique that helps you get the names right. If you're talking to someone face to face and you need to hand them your notebook and say, print your name for me, then do that. If you're on the phone and you can say to them, I'm going to read this back to you now, then do that. If they tell you their name is Nikki, ask them if that's a nickname, because their name might be who knows what. So please get the names right. Do the same with street names and with company names. And this speaks to something Mary talked about, which is our credibility. If you see a story in the paper and you are mentioned in that story, the biggest factor in whether you think that story is true or not is whether they get your name right. So get the names right. That's my big pet peeve.
I think it can be the best written story in the world, and if you have the names wrong, it's...
Hopefully that you all have an opportunity to read your stories before you submit them. Read through them, because you'll find things that, and when I edit a story, I need to go back over it, because if I've made major changes, I've probably messed something up. I've left a word in that I shouldn't have. So try to read it before you send it in. Homonyms. I'm always seeing homonym problems. Where, and the list goes on and on. There and there. So that's a common one for me. Titles. Titles before a person's name, before their name are always capitalized. When you say President so-and-so, it's capitalized before. If you say John Doe, President, it's lowercase. I see that a lot, the capitalization. I think that's some of the stuff I see.
I have one other, which is, and this is a factor of the immediacy of the publication, is fairness. Fairness becomes more of an issue because it used to be that a reporter got a tip. A reporter called the person. The reporter found out what the person was saying. The reporter had the time to then go say to the person that person was talking about, what do you say about this? And the story grew and grew and grew until at the end of the day, an assigning editor or a copy editor sat down and said, how do we make this fit together so everybody has a voice in the story? Well, today, the story goes up online when it's 2 sentences, and then it's 4 sentences, and then it's 6 sentences. And fairness necessarily, I think, gets short shrift in that presentation. And I haven't solved this. I don't know what the solution is. But just please keep in mind that if you're posting something and the story isn't finished and there is a way to try to make it more fair, either through background or by bringing in something that maybe the person you're talking about has said before that addresses this, then by all means throw it in. Put it in there if you can to make that story more fair until it is a complete story.